Well, one of the nation's most restrictive abortion laws took effect in Texas this week. The law bans abortions after 6 weeks. Now, this is after the U.S. Supreme Court did not take action on an emergency appeal, and those against the bill are calling it unconstitutional, saying it's too restrictive and goes against Supreme Court precedent. Our Andrew Bartline joins us in the studio now. And Andrew, Idaho has a law in the books that outlaws abortion in most cases. It isn't currently well enforced, but a scenario like this Texas law has the potential to kickstart the Idaho law, some say, and ban nearly all abortions in Idaho. What say you?
Yeah, currently in Idaho, abortions are pretty unrestrictive in the first trimester, but this trigger law is what they call it, would ban nearly all abortions in the gem state except in scenarios like rape or incest. So for Idaho's law to be triggered, a Supreme Court ruling or constitutional amendment would have to first grant the state that level of power. And the experts I talked to said the U.S. Supreme Court not hearing the case against Texas isn't enough to trigger that law. While it may look like Texas has been given authority to enact restrictive abortion laws against Supreme Court precedent, former Idaho Attorney General David Leroy says otherwise.
Their decision not to hear the Texas case does not restore to the states any authority to prohibit abortion.
The Supreme Court denied to hear an emergency appeal that could stop the Texas law from going into effect. The 6-week abortion ban in Texas will stand by default. But that alone doesn't push Idaho's abortion trigger law into effect. This isn't that trigger, correct?
It doesn't appear to be so.
To trigger Idaho's law, University of Idaho law professor Shakira Sanders says the U.S. Supreme Court has to make a ruling that the Texas law is constitutional. Looking directly at Idaho's bill, Section 1 says the law is triggered when the judgment in any decision of the United States Supreme Court that restores to the states their authority to prohibit abortion or the adoption of an amendment to the United States Constitution.
A particular state adopts a particular statute doesn't have any implications for this law in Idaho.
But just because the Supreme Court didn't hear the case against Texas this week doesn't mean another case won't come around.
So it is very likely that this case could end up back before the Supreme Court on the question of constitutionality, but that normally takes some time.
And the possibility of overturning precedent has Planned Parenthood here in Idaho concerned. They say this is a loud alarm that access to abortion is in real danger, especially here in Idaho. We are not new to this fight. We will not back down in our fight to keep abortion safe and legal in all states. Tell me one of the more unique parts here is that the law in Texas is on the books and it's free to be enforced, but the Supreme Court hasn't decided if that law is constitutional or not. She says normally there's a stay on the law where it isn't enforced until the court has made a decision. So that puts a lot of people in Texas in a weird spot right now. Mark?
It's complicated for sure. Andrew, thank you.